Okay.
Good evening. It is Monday, August 11th at 6:05 p.m. I am Jeffrey Whidden. This is the Law and Ordinance Committee. I am joined tonight by Mrs. Marshall and Mr. Twiss. Tonight we have two items on our agenda. First up is a recommendation to council regarding Ordinance 022-2025. This is a rezoning on Wilson Road. Mr. Titterington.
Thank you, Mr. Chair. It's actually a rezoning of 3 parcels on Wilson Road. Approval of the general plan for the new subdivision that would go there. The reason it's packaged together is because the request for rezoning is a planned development residential, not in a conventional district or request. This is 87 acres. It was discussed and unanimously recommended by the Planning Commission to seek council's permission. Again, it's about approximately 87 acres. It would consist of a layout of 3 similar but a little different lots. We've got 2 approximately 172, so not approximately, single-family detached lots that I believe, if I recall correctly, are maybe in the R4 zoning range, and then 39 single-family but 0 lot line attached, meaning they're doubles basically, two per unit, but they are single-family. They're just attached. It does comply with the comprehensive plan as well as the subdivision regulations. We are not requesting emergency legislation, and staff is here if you have any detailed questions.
Okay. I suppose I might, for Mrs. Rhodes there, based on some of the questions we got last week from residents that came forward. So some of the questions that we normally get for citizens when we bring these in are about what happened to a stormwater runoff. I'm assuming flooding is an issue for some of the residents that came forward last week, and could you just talk a little bit about that?
Yeah. So every subdivision that comes in, you have stormwater calculations or there's a stormwater calculation. They don't discharge any more than what was being discharged previously. So that's reviewed, and if we ever have any questions, we go to a consultant. So they haven't submitted that at the preliminary plan rezoning stage. They don't typically submit that. So that's one thing. There was a resident, I think, or a couple of residents on Kaiser Lane, and they're upstream, significantly elevation difference upstream. There was a couple on Peebles Road there in the FEMA floodplain, and they talked about having drainage issues. We will be reviewing this from a FEMA standpoint. There are a couple lots, a couple areas that are in the FEMA floodplain. There's also the entrance drive to, across from Heatherstone, across from Stonebridge Meadows. They'll have to cross the floodplain, so we'll work in and we'll follow those regulations, or the developer will follow those regulations. And then we won't be discharging any more, any less. So the residents, I think there was 2 on Peoples Road that talked, so they will remain in the floodplain. Their lots are low, so that is kind of why they're in the floodplain. Mm-hmm. But our discharge isn't going to make it any worse than what it is now. Right. He referenced Stonebridge Meadows and the discharge out along 718. The issue there is there's not an outlet. So it goes into the side ditch, but the outlet of the side ditch, there's kind of a hill that's there along 718, the side ditch. So that's why that is an issue there. But anyways. So we won't be making it any worse won't be making it any worse. What they bring to us, it'll go through a storm pond. It's a detention or a retention pond. Detention's dry, retention's wet. They retain water. They haven't determined, or I don't recall on the general plan them identifying which one, but it doesn't make a difference. The calculations will all remain the same.
Right. So it's fair to assume that whatever the plans, final plans may be, that they will be settled and the discharge out will be the same as it is now before those plans, before a shovel of dirt is turned on that.
Yeah, before,
Before the plans are finalized.
The calculation.
Yes.
yeah.
Okay.
Okay.
And then one of the other questions was about the traffic on Wilson Road. Has that been?
Yeah,
considered?
so I talked to the county engineer this week, or this week, and so there aren't, I said, are you aware of any issues out there? Right now, the volume of traffic's between 2,000, right around 2,000, give or take a couple hundred, vehicles per day. That's very, very low. And actually, we had counts from 2021, and they were right around the 2,000. So things may, depending on where construction is, may be increasing slightly. But with this property not having frontage along Wilson, there are no road improvements being proposed at this time. In addition to, with the traffic being so low there, being 2,000 vehicles, we're not really that concerned about it. Now, there is not to change the subject, but just there is another property, another development coming in, proposed rezoning south of here, and they will be doing an impact study because they have a lot of frontage, one, and two, they're right at the corner of Fenner and Wilson, which the county has identified as having issues, safety, traffic, accident issues, things like that.
Is it fair to assume that whenever we bring in a new subdivision and the proposed number of units, you guys can project the number of vehicles that would come with that, and that you can project those out further?
Yes.
Okay.
So that is typically what does occur. But again, with the vehicles being so low and having two entrances, there isn't any improvements proposed at this time. Okay?
Thank you. Mr. Trust, do you have any questions?
No, you answered mine on the roads, because there was two entrances, so traffic should be able to flow out both sides better than one. And it's not going on to Wilson. There's no exit onto Wilson?
Yes.
That's the second exit.
Both exits are onto Wilson.
Onto Wilson,
Yes,
on each end?
yes.
Okay.
Not Fenner.
Not Fenner.
I don't know what you're... Okay.
I'm confused. Okay.
The one exit is directly across from Stonebridge Meadows,
Oh.
Stone Drive.
Yeah. Got it.
So that'll kind of become a four-way
Four-way.
intersection, two-way
Okay.
stop. And then the other one is just south of there, less than a quarter of a mile.
Okay. That makes sense.
Mrs. Marshall?
Well, you answered my questions, traffic and flooding. Somebody had asked about the water, if it was going to be city or well water. It's city, right?
Yes.
Okay.
And with this being a planned development, we won't be doing any fees in lieu of, they'll take care of the recreational.
There is green space improvement, with some amenities that the developer has proposed as part of his plan.
Okay. Do any other members of council have any questions? Mr.
Not
Phillips?
necessarily a question, but I have a comment.
Sure. Mr. Phillips?
I will say that of all the developments that come through council over the years, the retention detention ponds and all of the runoff that has been captured have presented zero issues over 16 years that I've been on council. And I will point out that this year, the subdivision that is at Nashville and 55, just west of Kensington, where I live, it was in heavy construction. The retention detention ponds had been built and were working. However, the developer, when they connected their 48-inch, I think it was, two 48-inch pipes to run under Nashville and connect into our runoff canal to go east, they rose up out of the ditch. They hadn't cemented them in place yet. And they did, we had an extreme rain event at that time, and the water was extremely high in the ponds. In fact, it was running over Nashville Road and did flood a couple of homes across the street on the east side. The developer, when he was notified, was on site within 20 minutes and got the pipes down. Took him about another 20, 30 minutes. Once those pipes got down, that water, which would have been discharged for the first several hours, again was extremely higher. The water level went down and it handled the water adequately. And that's what I have seen with all of the subdivisions that have gone on, again, with my time on council here, so that they're overbuilt. I mean, they do that on purpose so that things work properly and nothing comes back on them. As to the traffic issue and the schools issue, that questions were proposed in talking to Chris Piper at the school system, that they are, I can't remember his word, but they're flatlined basically with school population, and they're not worried for the next several years about the school children population, even with new subdivisions coming in. Just information that I gathered.
Yeah, thank you, Mr. Phillips. Do any other members of council have any questions? Any member of the public? Do you have a recommendation?
Move forward to council.
Move forward.
It is unanimous. Sorry, say it one more time.
No emergency,
No.
right.
Thank you. It is unanimous to move forward with that. Our second second item on our agenda tonight is a recommendation to council regarding joining the City of Columbus in filing an amicus, am I saying that right? Amicus brief with the Ohio Supreme Court. Mr. Titterington.
It's an amicus brief, and it was requested of the Director of Law, Mr. Kerber, who is out of state, so could not be here tonight. The Ohio Municipal Attorneys Association, which is pretty much the statewide municipal attorneys, they are requesting the city to sign its name to an amicus brief that will be filed by the City of Columbus on behalf of, or in support of the City of North Canton, in a case that's North Canton versus CF Homes LLC. Without getting too far into the weeds, because I really can't, it is a property maintenance case. The challenge is from a landlord that believes that the standard for obtaining a search warrant should be a higher standard than what is been practiced and has been the interpretation, for lack of a better word, for a long time. Currently, if you have a reasonable government interest justifying the intrusion of the property, you have to demonstrate that to the court, and you can get an administrative search warrant. In our case, for example, getting inside for property maintenance is far less usual than the exterior of the property, but whether it's interior or interior, the standard that Mr. Kerber has always directed us to have to demonstrate is basically it's got to be visible, it's got to be clear and present if we can see it, and then document why we believe there's a property maintenance. Then we have largely been successful in getting a search warrant to be able to then document and follow up and get as much information as we need to make sure that the property maintenance issue is abated. The landlord is claiming that the standard is and should be, or is in the Ohio Constitution, that we need probable cause that criminal conduct is likely to be uncovered. That is a much higher standard. That is not the standard that we use. Our standard is consistent with the federal constitutional law. And again, we are asking that council authorize the city signing on to this. Mr. Kerber is in support of this, and there is no cost to us. And we are requesting emergency legislation because it has to be filed. We received notice and the request last week, and I believe the deadline is September 10th to let them know whether we would be signing on to it.
Okay. With my conversations with the city law director, and just want to reiterate again that this would be no cost to the city if we agreed to sign up for this, and no consequences, win, lose, or draw of the outcome of the case for the city, correct?
Correct.
So
whatever the Supreme Court would decide would be either reaffirming the standard we're using, or we would have a new standard that we would have to follow.
Correct. So my understanding of the case in and of itself and how it applies to Troy is that this is a commercial property, a commercial realtor, not a family who owns two homes, one in which they rent out. This is a commercial apartment building to which there was the dispute over, I believe it was about a sprinkler system, inspecting that.
This immediate case has
Yeah.
to do with the rental residential real property inspections programs.
So am I wrong in saying that this was not a commercial property? It is
I'm not sure what the exact property was in North Canton, but I don't know that there are two standards, a different standard between commercial and residential.
Yeah, okay, I see what you're saying there. There's probably not two standards, but this was, from what I understand, it was a traditional apartment complex versus an individual or private home that someone is renting out.
I believe that's correct.
Okay. Actually, hold on 1 minute. Mrs. Marshall, do you have any questions?
So dumb this down for me a little bit. This is, they're wanting to be able to go into a house, a rental property, if there's something wrong with it and they weren't allowed to? Like what?
So I don't have the facts of the case, but I can tell you that, if we want a search warrant to inspect what we believe may be property maintenance issues, we have to be able to see that there's a potential violation happening, whether it's maybe in the backyard or inside the property. In a recent case, we received a search warrant to go into the backyard because we could clearly see that there was a lot of accumulation of stuff. And in so doing, then we're able to see in the house, and I don't know if it was a window or what it was, but that there were potentially some significant issues inside the house, and then we're able to get another search warrant to search that property. That's the standard that we've been following. That's the advice that we've been given by Mr. Kerber. I can't give you the exact the legal distinction between what CF Homes is arguing, other than they are arguing that there is a much higher standard before a judge should administratively be able to issue a search warrant to a municipality.
All right.
Mr. Twiss?
I have no questions.
Do any of the members of council have any questions? Mr. Sievert?
Two, I think there's a little bit of a distinction between that. The actual statute involved in this is where a landowner is saying that the city had an ordinance in place that said, if you do not allow us to inspect, we have the right to go back in and inspect on a rental that becomes vacant. So that's really what they're arguing is, we don't have that. There's been some discussions about that happening in Troy, but that is a distinction. And then I guess the question I would have to Mr. Tiddington or to Ms. Dyder, whomever, is, well, I guess I'm just not sure why this came to council. Are they looking for us to just agree, or is there because I know in the past when we've had litigation, it's only come to council if we've reached a threshold of economics, and I don't think that would have occurred on signing a amicus brief.
I want to say that maybe this has happened once or twice since I've been here anyway, and so it doesn't happen that usual. It's not that usual. The financial threshold is entirely different. Mr. Kerber asked that we bring it to you and get authorization from you to just sign the city's name to
So will we have legislation on Monday?
resolution?
A resolution?
Simple resolution authorizing the city to join.
At no cost.
I know, yeah.
I know, yeah. And it's a good, I mean, I'm supporting it. We should do that. I just thought it was odd that we did it that way. Thanks.
Yeah, I had a good discussion with Mr. Kerber on this topic on Friday, and I am comfortable with moving forward with this, though I was kind of hoping he would be here tonight. Do we know if he will be back next Monday?
He should be back
Yes.
next month.
And can we ask him to give a full brief to council on this before we do final vote to bring this forward?
Well, sure.
Yes, we will ask him.
It's a little bit out,
I mean, that was a
legal
softball
question's a little out of my
question, I
depth.
understand, so I'm sure he would be glad to do that.
Okay. Mr. Twiss, do you have a recommendation?
Move forward to council.
Move forward.
It is unanimous to move forward. Is there anything else to come before?
With emergency.
With emergency, yeah.
All right, you okay with emergency?
Of course.
Very good.
It is unanimous. Is there anything else to come before the committee?
No,
No.
sir.
We are adjourned. Thank you.